welcome to the podcast of the Andrea Mitchel Center for the Study of Democracy at the University of Pennsylvania. I'm Matt Berkman, and our guest today is NEETI NAIR, Associate Professor of History at the University of Virginia, and the author of Changing Homelands, Hindu Politics and the Partition of India. She's currently working on a comparative legal and political history of hurt sentiments in India, Pakistan, and Bangladesh. Nair has held fellowships from the American Council of Learned Societies, the National Endowment for the Humanities, the American Institute of Indian Studies, and the Harry Frank Guggenheim, and the Andrew Mellon Foundation. It's a lot of fellowships. She is also a global fellow at the Woodrow Wilson International Center for Scholars in Washington, D.C. Welcome to the podcast, Professor Nair.
Thank you for that kind introduction, and thank you to the Andrea Mitchel Center for this very kind invitation to share my research, and I look forward to your questions and to this conversation.
Thank you for being here. In your new book project, you're looking at India, Pakistan, and Bangladesh, and you're telling a story about the development of law, policy, and political discourse around this idea of hurt sentiments. So I'm wondering if first, can you tell us, can you just explain the phrase hurt sentiments, tell us its origins and the different ways that it's been deployed over time?
Sure. So the phrase hurt sentiments has become a way to quickly reference legal cases that are filed allegedly because the litigants' sentiments are hurt by a publication or a speech, a film, or a cartoon even. The idea that Indians were especially predisposed to having their sentiments hurt or wounded is first elaborated upon by law member in the East India Company, T.B. Macauley, in his draft note on the Indian Penal Code in 1837, almost 2 centuries ago. Macaulay held that there was, and I quote, "no country in which the government has so much to apprehend from religious excitement among the people." In framing the chapter of the Penal Code on offences relating to religion and caste, he argued that the British wished, and I quote, "to allow all fair latitude to religious discussion, and at the same time to prevent the professors of any religion from offering, under the pretext of such discussion, intentional insults to what is held sacred by others. We do not conceive that any person can be justified in wounding with deliberate intention the religious feelings of his neighbors by words, gesture, or exhibitions." However, he went on to record exceptions, such as, and I quote, "a warm expression dropped in the heat of controversy, or an argument urged by a person in good faith for the purpose of vindicating his own, will not fall under the definition contained in this clause." We find the same argument being made throughout the colonial period about Indians' propensity towards getting their religious sentiments hurt, and we see a similar caveat for exceptional situations, such as when a person, let's say an academic, might make an argument in good faith during debates to amend the Indian Penal Code a century later in 1927. In the post-colonial period, that is after India and Pakistan became independent in 1947, debates on whether a book or a film, a politician's speech, or a stand-up comedian's performance have hurt sentiments have breached the domain of the courts. What we now see in all the 3 countries that continue to use Macaulay's Penal Code in amended form is increasing recourse to extra-judicial authority to claim justice, or rather vengeance, for these hurt sentiments. Let me give you one example that will interest those involved in free speech on campuses. An academic essay on the Ramayana, written by the renowned philologist and poet A.K. Ramanujan, titled 300 Ramayanas, 5 Examples, and 3 Thoughts on Translation, that a litigant, Dinanath Batra, argued hurt Hindu sentiments, was ultimately removed from a graduate history syllabus in Delhi University in 2011, not because of any judicial ruling, although the matter did go to the courts, but because the vice chancellor of that university, its president in effect, was persuaded to do so by a right-wing student political party that represented the same cause as the litigant. So it wasn't expert academic opinion on the quality of the essay or judicial opinion that decided the case, but a combination of the brute street power of a right-wing student party and more than a streak of authoritarianism on the part of the vice-chancellor. Emboldened by this easy victory, the same litigant went on to demand the banning of more books and succeeded each time in cases that were often resolved outside the courts. So hurt sentiments, once sought to be contained within the four corners of the Indian Penal Code, is now primarily adjudicated outside the courts. I should add that the 2017 Law Commission of India report on hate speech uses the phrase hurt sentiments to argue for new legislation that will prevent a new class of injury amounting to more than, quote, hurt sentiments, but to less than harm in the sense of physical injury, close quote.
Thank you. In the book project, the parts of it that I've read, you're writing about the assassination of Gandhi in 1948, and also about, more specifically, about the trial, the execution, and then the subsequent rehabilitation of his assassin, Nathuram Godse. I'm not sure if I'm pronouncing that right. I hope I am. Could you tell us that story about Godse as it relates to this overall argument of your book about hurt sentiments?
Sure. When I began to study Gandhi's assassination, I was aware that his assassin Nathuram Godse's defense statement had been censored and banned from publication within India. I hadn't read it myself, and so I was interested to learn why it was censored. It was finally published in English in 1977 when a non-Congress party formed the government. Today, it is widely circulated on all sorts of websites with ponderous voiceovers reading the text and juxtaposed with images from the trial. Godse's statement at the Gandhi murder trial is a textbook example of what constitutes Hindu hurt sentiments. His defense statement is reflective of the time of partition, a time when many Hindus believed that the Congress had indulged in what they called Muslim appeasement and carved out a territory called Pakistan out of what these Hindus called undivided India or Akhand Bharat. He invoked the past as a series of blunders and argued for a Hindu theocratic state in the guise of secularism. He also used a fair bit of what we would today call fake news and misinformation. Now, what is erased from from Godse's defense statement is the extent to which the organizations to which he owed allegiance, that is the Hindu Mahasabha and the Rashtriya Swayamsevak Sangh, the RSS, themselves perpetuated the idea of Hindu supremacy and two nations. As I explain in my first book, Changing Homelands, Hindu Politics and the Partition of India, it was ideologues of Hindu supremacy such as Bhai Parmanand, who wrote in 1929 in a book called The Hindu National Movement that, quote, the Hindus and the Muslims differ from each other in every respect, and that the idea of a common nationality is for the present impracticable in India. This was published 11 years before the would-be founder of Pakistan, M.A. Jinnah, made a similar claim that Muslims and Hindus constituted two distinct nations. So it was a bit rich now in his partition writings and in his trial in 1948 for Nathuram Godse to lay the blame for partition on Gandhi and the Congress party and thereby seek to justify his assassination of the Mahatma. The work done by hurt sentiments in Godse's defense trial is, I believe, fundamental to understanding contemporary concerns over Muslim appeasement that are floated by Hindu supremacists in India today. It is the same Hindu hurt, for instance, that was invoked during the years-long assault on the 16th century Babri Masjid in Ayodhya, leading to its destruction in December 1992. Understanding the roots of this Hindu hurt takes us back to the fundamental fault line running through post-colonial India, the great divide between Godse and Gandhi. I explore this alongside the gradual appropriation of Gandhi by the Hindu right and its consequences for the development of Indian secularism.
Well, that's a great opportunity for me to ask you about this concept of secularism, which features so prominently in your new project. How have South Asian interpretations of secularism changed over time, and what have been the consequences for speech and religious expression of those changes?
Thank you. So I realized as I proceeded with my research that it was impossible to study these instances of hurt sentiments without situating them in the prevailing state ideologies of the day. I also found that outside the Constituent Assembly, the term secularism had gained quite a bit of popularity, so much so that even the newly repurposed Hindu Mahasabha, unbanned 6 months after Gandhi's assassination, declared that it stood for a secular state in India. The only difference is that the Hindu Mahasabha argued that Hinduism was inherently secular and tolerant. It was other religions that needed to learn tolerance from Hinduism, so on and so forth. As far as India is concerned, secularism has never meant the separation of church and state. When deployed by members of the Congress party or academics who have written about the ideology, it has typically meant equal distance from all religions, or as some scholars have suggested, equal intimacy towards all religions. In my research into parliamentary debates at the time that a constitutional amendment was introduced to insert the word secular into the preamble to the Indian Constitution, I found that by the mid-1970s, secular had come to encompass an aspiration across different classes, castes, and regions. But it was also widely recognized that secularism had suffered in implementation, and that there remained a wide gap between the rhetoric of Indian secularism and its practice. So parliamentarians of all political parties, while swearing by secularism, also wished to see plans and policies put in place to ensure that religious minorities would be better represented in educational institutions, in appointments in the high courts, in public and private sector enterprises, in government. In short, they were asking for affirmative action or reservation to be introduced for Muslims as well as for scheduled castes and scheduled tribes who had converted out of Hinduism. And I find that all these demands were eventually negatived by Indira Gandhi's party during these debates, which is during the emergency, when she not only had a majority from an election held 5 years ago, but she had also by then arrested much of the opposition and clamped down on civil liberties. Now, as far as censorship in India is concerned, if you look at case law alone from the 1950s through the 1980s, there is no progressive tightening of censorship. However, other arms of the state and other ministries, such as the Home Ministry, begin to get interested in the nitty-gritty details of censorship. So I came across this effort in the Home Ministry to set up a book censor board that would censor books coming from overseas and thereby stop their import by way of the often used Sea Customs Act, that is to say, without public debate. Now, the difficulty lay in constituting a book censor board. So in Britain, for instance, both E.M. Forster and T.S. Eliot rejected being part of such a board, raising the valid question, quote, how should we trust the person who chooses a board to choose the right people? End of quote. So because the decisions to accept the charge of hurt sentiments, whether taken by a book censor board or the vice chancellor of a university, were taken outside the courts, I don't think it is useful to restrict oneself to case law while studying cases of hurt sentiments. If it is street power that is enforcing its diktat, it becomes necessary to see how that is dealt with politically. So this is a political history about the management and regulation, and in some instances, rechanneling of hurt sentiment into something that can potentially get more votes. Then the question to ask is, how do the guardians of Indian secularism respond in such a situation? And the verdict is clear, even more so in retrospect, right? They do so pathetically. Let me quote an expression that I came across that was used by numerous sympathetic contemporary commentators in the 1990s, and I quote, secularism cannot operate in a vacuum. End of quote. But why was this vacuum allowed to develop by the 1990s? Why wasn't more done to give substance to the rhetoric and demand for secularism over the course of so many decades? A study of the way cases alleging hurt sentiments have grown exponentially in recent years can also help us grapple with the limits of secularism as containment or management of religion. The state ideology of Indian secularism today is a byword for Hindu majoritarianism.
Professor Nair, your story begins with Indian independence, but it goes all the way up to the 2019 Citizenship Amendment Act, India's Citizenship Amendment Act. So let's talk about this contemporary context. What did the 2019 Citizenship Amendment Act do? What kind of change does it represent from the past? And how does that controversy relate to the concept of hurt sentiments?
The Citizenship Amendment Act of 2019 makes it easier for Hindus, Buddhists, Sikhs, Christians, Parsis, Jains in the three countries of Pakistan, Bangladesh, and Afghanistan to get Indian citizenship. They have to provide some sort of proof that they have been persecuted as minorities in these countries, but we don't have details of what this proof will have to look like. Now, the biggest objection to the act is that by excluding Muslims on the grounds that they are not minorities in these countries and therefore not worthy of being considered as persecuted, this is an open question. This raises other questions which we can come to later. What the act does is it opens the way for Indian Muslims to be targeted and accused of being illegal immigrants. The reason is that the documentation that is required to prove Indian citizenship is onerous. And we know this because of a recent exercise called the NRC, the National Register of Citizens, that was carried out in the northeastern Indian state of Assam. The paperwork required to prove that every Assamese resident was a citizen was so draconian that many were unable to do so, and their paperwork was dismissed for reasons as minor as a typo in some cases. Eventually, almost 2 million names were omitted from the dreaded NRC list, and the fear is that these doubtful cases are going to end up in detention centers for the rest of their lives, and these detention centers are actually being constructed across India. Now, if this exercise of determining citizenship is allowed to be carried out throughout India, it will amount to legislatively sanctioned persecution of India's Muslims, since those found to be lacking proper documentation will be labeled illegal immigrants from Bangladesh or spies from Pakistan and be put into detention centers. The Indian judicial system being as slow as it is, they will end up staying there for the rest of their lives. And we know this from the experience of so many Muslims, especially from Kashmir, who have spent years as under trials in prison. So at its core, the movement of people resisting the Citizenship Amendment Act, the question is, this is about, it's a question of amending the Citizenship Act so as to make it easier for people of a particular religious community to get Indian citizenship. So at its core, it's a question of who has the right to belong to India on terms of equal citizenship, a fundamental right enshrined in the Constitution. Now, according to the Home Minister, Amit Shah, the act is about undoing the wrongs committed by the Liaquat-Nehru Pact of March 1950, a pact that was forged to provide security to minority communities in the wake of the horrific violence that characterized India's partition. Now, this reference to the Liaquat-Nehru Pact was part of Amit Shah's speech and rationale in Parliament on December 9th, 2019, hours before the act was passed. This is why I see the CAA as aiming to fundamentally transform the character of India to make it a Hindu Rashtra, a Hindu state for Hindus in the main. So the charges of hurt Hindu sentiments that have repeatedly been flung at Muslims, for instance, in the build-up to the movement to build a temple to the Hindu god Ram in the late 1980s, early 1990s, are also trying to achieve the same goal, that is, to build a Hindu Rashtra. What is the secular response to the repeated charges that today's Muslims are responsible for causing Hindus hurt and trauma for the destruction of temples that may or may not have happened hundreds of years ago. Whether you define secularism as equal respect, equal distance, or equal intimacy towards all religions, or the state's regulation of religion, it has to stand for something when minorities are threatened. And that has been its greatest failing. What we have instead seen is that the judiciary and almost the entire political leadership has been towing the lines dictated by the Hindu right. But I see hope in the commitment to secularism that drove the anti-CAA protesters. And this to me suggests that it might make sense now to make a distinction between state secularism, which is increasingly absent, and everyday or popular secularism, which might be on the ascendant.
So it seems from what you've written, and you've talked mostly about India now, but in what I've read, you're looking at India, Pakistan, and Bangladesh, and it seems that you're identifying a similar pattern in each state in which all three states have gradually abandoned some previous level of minority protections in favor of more majoritarian and exclusionary laws and policies. So my question for you is, what explains this pattern that we see across all three states?
Yeah. So I examined some of the debates about protection for religious minorities in India and Pakistan in their founding years, and later in Bangladesh, because after all, the partition was supposed to have resolved the problem of India's religious minorities. As we can now see so clearly, it did nothing of the sort. So my study of these debates suggests that there were crucial design flaws in the constitutions of all three countries. What is interesting to me is how these flaws, the lack of sufficient safeguards for minorities, were the subject of intense debate, especially in Pakistan, where the Bengali Hindu and Punjabi Christian religious minorities were extremely vocal about their uneasiness in a self-professedly Islamic state that also saw its own creation as the product of not wanting to be a minority in undivided India. So Pakistan's founders took particular care to at least verbally address and assuage the concerns of their new religious minorities. In my reading of the debates around and following the Objective Resolution of 1949, these concerns were addressed, which is why these very vocal minorities decided to give their new nation state a real chance and decided to stay in Pakistan. Now, what has happened in subsequent decades, especially after the War of 1971, is that Pakistan decided to double down on its Islamic credentials to curry favor with the Arab world, especially after the oil crisis of 1973. And as noted by anthropologist Asad Ali Ahmed, General Zia's additions to what are called the blasphemy laws were an attempt to shore up state authority in the face of social and religious agitation. In the case of Bangladesh, there was too little time for the war-torn country to even try and implement secular principles, always defined as being not against religion, but for harmony between all religions and against the misuse of religion in politics. Barely 2.5 years separated the ratification of the new Bangladesh constitution and the assassination of Bangladesh's almost entire political leadership. The Premier Mujib Rahman's successors were the military generals Zia-ur-Rahman and H.M. Ershad, and they both moved to bring Islam and Islam-based political parties back into the mainstream in order to shore up their authority. Safeguarding the rights of religious minorities under these circumstances was not a priority. In the case of India, I think we need to revisit the founding years to look more carefully at the role of the Hindu right in influencing and shaping the drafting of the constitution, much of which might not be available in the recorded minutes and proceedings of the Constituent Assembly. So we have to look at other sources, not just the debates in the Constituent Assembly.
My final question is, you addressed this at the beginning, but I thought maybe you'll have more to say about it, because it's a point that we hear a lot about the way that former colonial regimes impacted legal structures of post-colonial states. So my question is, can you say more about to what extent the legacy of British colonialism features in the story that you're telling here?
Yeah. So, it's been more than 70 years since the British transferred power and India and Pakistan won their independence. And I have in an article on the history of Section 295A of the Indian Penal Code, colloquially referred to as the Blasphemy Law, that was adopted in 1927, almost a century ago. I have argued that the law was a product of the collective endeavors of Indian legislators and the British, so it isn't strictly accurate to call it a mere colonial law, although it was certainly a product of politics in colonial India. Now, although it is possible to draw a line that connects the obsession with litigation around hurt sentiments today with Macaulay's concern not to wound the religious sensibilities of Indians 2 centuries ago, I think it would be disingenuous to do so. The work done by hurt sentiments today is of a profoundly different order than in the colonial period. Indeed, myriad calls to reform India's criminal laws have recognized this, and the same is true for the case of Pakistan, where the Zia era laws, there's a real call to reform these. And I think it's also instructive to learn from Britain's own experience of her blasphemy law. It took multiple attempts over the course of 2 decades for the House of Lords and the House of Commons to finally abolish the laws of blasphemy and blasphemous libel in 2008. And this is despite the fact that the law had last been used in 1977. At the same time, it took multiple attempts to amend the Public Order Act of 1986 that bans incitement to racial hatred, so as to make it include the offense of stirring up religious hatred. All of this is to say that colonial legacies notwithstanding, I see the increasing use of these laws and the will to reform these laws as a product of more recent politics.
Professor Nair, thank you so much for being with us on the podcast.
Thank you. Thank you so much for having me over. Thank you.